Welcome to Looking at Legal Stuff. Today we have 11 hearings, including 5 new updates, in a case of a couple where Dad says he wants a separation, but Mom says she wants a divorce. Dad says she's been withholding visitation since they separated, but Mom says that's because she wants him to have supervised visitation, because she says he has mental health and substance abuse issues. Mom also has a problem with Dad's brother, a sex offender with whom he lives, and doesn't want the children around him, but she says Dad doesn't take her seriously. Let's see what the judge thinks.
All right, Bissig and Gibson, 23-300-30808.
I'm here.
All right. Good morning. I keep wanting to say afternoon. And it looks, I have Zach Bissig. Can you hear us, Mr. Bissig?
Yes, I can.
Okay, perfect. So, I have a temporary family law order that's been submitted by Ms. Gibson along with a temporary parenting plan. Mr. Bissig, have you been provided those proposed orders?
Yes, I have, and I have responded with a declaration.
Was that the one that was filed on the 1st?
It was filed last Friday. Yeah, the 1st.
Hold on here. All right, is this y'all's first appearance in court on this matter?
Yes, Your
Yes.
Honor.
Okay. All right, just give me one moment. All right, and this is a petition just for legal separation, not dissolution. Is that correct?
Yes, and a parenting plan too.
And I do not agree to the legal separation. I want to be divorced, not legally separated. And also, Your Honor, I did not receive anything for a response from Mr. Bissig.
Mr. Bissig, did you serve Ms. Gibson with your response?
Yes, my legal advisor told me I could mail it to her, so I did that.
All right, I don't have okay, a couple different things. I don't have a declaration and confirmation of service. I don't have a anything that the court stated that there was an agreement to service beyond either direct service. So normally there needs to be an order that the court grants for service by mail. You can't just mail someone something and consider that service unless the court authorizes that.
That's on Mr. Bissig's part, not on mine, correct, Your Honor?
Well, if you didn't receive the stuff from the 1st, then there's no confirmation of service in the file for anything that was filed on the 1st.
Oh, just wanted to make sure. Thank you.
So I don't know who told you that that's okay. It is okay if the court allows you to or authorizes a service by mail. All right. I hate having to do this, but this is what I'm going to do. I'm going to, I think it's important for the court to have all the information to make a decision. So I have 2 options right now. I can either disregard everything that was filed on the 1st, which obviously would be, would probably not in Mr. Bissig's best interest, or I can require him to serve Ms. Gibson with all the information that was filed. So that looks like it was 10 pages of text messages and photographs and a declaration affidavit that was provided and signed. And there's some attachments to that. And set this over 1 week to the 13th. So that's what I'm going to do. So Mr. Bissig, you need to serve those on her personally, not you directly. It needs to be a non-party to the case and file proof of service. And then we'll come back on the 13th to hear the matter and get temporary orders entered. Okay. And I do, for the record, have both a proposed parenting plan from Mr. Bissig and a proposed parenting plan from Ms. Gibson. Those will, I'll ask the clerk to retain those, so the court has those for our hearing next week. So you don't need to refile those unless there's something about them that you want to change between now and next week. Okay, so Mr. Gibson, if you don't serve her those documents and provide proof of the service, then next week the court's just going to move forward without considering those documents. Okay.
Okay, Your Honor.
All right. So set it over to the 13th of September at 9 a.m.
Thank you, Your Honor.
Thank you.
I think I have Zach Bissick online, and do I have Megan Gibson?
Yes, I'm here, Your Honor.
I'm here, Your Honor.
Let's talk about your case. This is 23-300-30808. I have temporary orders that have been filed by Ms. Gibson. I don't know, Mr. Bissick, have you received these orders?
Yes, I have, Your Honor.
Okay. Let me just jump into your digital file here.
Your Honor, I do want to just say, due to some medical issues over the last week, I was unable to get my evidence served to Zach Bissig that I had filed with the court. I ended up in the hospital with a concussion and a bruised tailbone and have been on bed rest since.
Okay. And that was some of the documents that you filed in support of your temporary orders?
Yes, they were my evidence for why I feel the temporary order I had submitted to you guys was necessary.
Okay. Mr. Bissick, my understanding is you have filed your own temporary orders and proposed parenting plan in this case.
Yes, Your Honor, and I have served her already.
I saw that you had served her. I think the concern when you all were in front of the last judicial officer was proper service. And it looks like we still might have an issue, Mr. Bissick, of you being properly served with all of the documents that the court would be relying upon today. So let me ask you, Ms. Gibson, when do you believe you would be able to get that served on Mr. Bissick?
Honestly, Your Honor, at this point, I would like to just move forward and strike out my evidence and go off of, I did prepare a statement if I'm allowed to read it, and just kind of just go forward. My head is throbbing due to my concussion, and I don't know when I'm going to be better, let alone filling up for everything. So I would like to just move forward.
Right. So I wouldn't be allowing you that kind of testimonial statement. Again, we're without Mr. Bissick being given a heads up on what that is. That's why we require these to be done with declarations. We don't do trial by surprise here. So if you are saying that there is something that you are going to rely upon in this hearing for temporary orders, I do need to have you serve it on him. We could ask Mr. Biscuit, excuse me, my mouth is dry. I need to stop drinking coffee and move over to water. If you would be willing to accept service of that by email, we could probably get that done much quicker than if it's personal service. I don't know if that appeals to the parties in any way or is acceptable to you, sir.
Not really, because I do know for a fact she was at the bar last Saturday. So I think she had plenty of time to do it, and she's just making excuses now. And it's already been a while, and I really want to see my kids and get this going.
Well, I understand, but I'm telling you that she, whatever the reason, she has documents that she is going to serve on you. Would you agree to have those served by email, or would you like those to be served on you personally before we move forward? If she does it by email, we can get you back on the docket much quicker.
How much further would it be if she personally has to do it?
Well, it depends how long it takes to find you and personally serve you.
I'll just take the email.
Sorry, I couldn't hear you.
I'll just take the email, Your Honor.
The email. Ms. Gibson, are these documents that you can serve by email?
Yes, one of them is a statement, and then I have all the pictures that I had submitted to the court already on my computer that I can email to him as well.
Okay. Please get those emailed this week so that he can file any objection or response to that evidence. And then I'm going to set you to the September 27th, 9 a.m. docket.
All right. And then for the statement, it's not something that I had submitted to the court. I would need to get that also submitted to the court along with my proof of service.
Yeah, you would want to do it as a declaration. Yes.
All right. Just want to make sure. Thank you so much, Your Honor.
Yes. And then you both can log in via Zoom. I'll keep your temporary orders here that you've both proposed, and we'll see you back on September 27th at 9 a.m. To be real quick, so this may be something we set over, but I'll hear from the parties first. Number 21 on our docket of 21 is 233-0030-808. This is Zach Biskig and Megan Gibson.
I'm here, Your Honor.
I'm here, Your Honor.
Thank you. I know this has been a very, very long docket. My apologies to you. Because you are the most recently filed case, as you can hear, some of these cases have been going on since 2021. I know yours probably feels like a long time. You filed in July of 2023, but as you can see, you are the most recently filed case. We were together on September 13th, and I think at that time we were discussing mailing of evidence to the other parties. I'll get some brief input from you, but then I will just have to give you a new court date.
Okay. I was able to email the documents to Mr. Bissig, as well as turn in my declaration to the courthouse. You should have the proof of mailing or hand delivering in the system, as I did turn that in last week.
And I have your temporary family law orders here. Have you also served these on the prosecuting attorney's office?
I was unaware of having to serve to prosecuting attorney's office.
Okay. Go ahead, Ms. Looney.
Your Honor, we have already sent out proposed child support worksheets to the parents. We're aware of what's happening in the case. We're just waiting for a temporary order to be entered so we can request a child support hearing date.
Got it. Okay.
Your Honor, there is already child support ordered towards Mr. Bissig to pay. He is now $1,350 in debt to the state.
So, yeah, hold on, ma'am.
$1,350.
Okay, so, sir, what is your position on, have you now received the proposed temporary orders?
Yes, and I also responded back to her.
Did you file your own proposed orders?
Yes, I'm the one that started it all.
Sorry, I'm having trouble understanding you. You did or did not?
Yes, I did. I was the one that started it all.
Okay, maybe I don't have those as originals in front of me. Are you talking about, nope, those are hers. The July 25th proposed parenting plan, is that what you're talking about?
Yes, I did that one.
Okay. Is your current request the same as what you requested in the July 25th parenting plan?
Yes, for my temporary one.
Okay. So I'm going to do this just because of our time. I'm now 40 minutes behind starting my next docket. I'm going to give you all a new court date. Do either of you expect to be filing any additional documents before I make a decision on your temporary orders?
No, I don't plan on unless she does something for me.
Okay. Ms. Gibson, do you intend to file any additional documents before I rule on the temporary orders?
No, Your Honor, I've submitted everything I needed to.
Okay, let me look and see. I could put you on next week, but let me see how many we have already.
There is just one thing, Your Honor, with
Just
the
hold on, ma'am. Just hold on. Okay, right now we're sitting at 9 cases next week. That probably will go up a little bit, but we're not going to be anywhere near the 21 cases we had today. So since you all have submitted all of your paperwork, I'm going to just bump you over 1 week to October 4th at 9 a.m. Does that work for you, Ms. Looney?
Your Honor, the state's request would just be if we could set it out slightly longer. That would
Okay.
give us time to get a child support order proposal out and do everything on the same day.
Perfect. Let's do that. What are you thinking? 4 weeks to give time for service and any response?
3 to 4 weeks should be fine. We could get the order out fairly quickly. We'll be using the same worksheets we've already sent out to the parents with our proposed worksheets and notice of parents back in August.
Okay, so to the parties, I'll give you the choice between October 18 or October 25th. What works for you? Mr. Bissick?
The sooner the better, please.
Okay, we'll do October 18th. Ms. Gibson, does that work for you?
I'll make it work to the best of my ability.
Okay, so October 18, 23 for review of the temporary orders. And then Ms. Gibson, you had a question?
It was just about setting it over because I do have a job and I work mornings. I will be working that day, so I'll just have to try to see if they can get my shift covered out.
Yeah, understood. If you run into issues with work, we certainly don't want anyone to lose their job over having to come to court. If the 18th is not doable for you due to work, please reach out to court administration and we can handle that, okay?
Okay, yeah, I'll talk to them because I've already missed 3 days for court already. So
Yeah, I mean, as
Oh.
you've probably heard from a lot of the parties here,
yeah,
they've been in court for years. So
yeah, so
this is a marathon, not a sprint,
Yeah.
unfortunately, and I feel your pain. I'm not, trying to diminish that at all. But again, I think the remedy here is if it is a problem for your work, just let the court know and we can work with you.
all right, thank you so much.
Okay, thank you both.
I got a question real quick.
Okay, go ahead.
Since it's taken so long, I would like to be able to visit my kids. Is that anything possible?
Yeah, I'm not going to make any rulings right now on visitation. I'm going to just reserve all of it for October 18th, okay?
Okay.
All right, thank you both. You're free to log off. The Zach Bissig and Megan Gibson case 233-0030808. And Ms. Looney is on that matter. Thank you everyone for being patient. Let me grab the files here. Ms. Gibson, can you hear the court?
Yes, I can.
Okay. And
Can.
Mr. Bissig, can you hear the court?
Yes, I can.
Okay. So this is 233-0030808. Just opening up the digital file here. What I have in front of me are temporary orders proposed by Ms. Gibson, it looks like. And then I also have the state's motion for a child support order. I guess, Ms. Looney, first I'll turn to you on the state's request.
Thank you, Your Honor. I am not sure, but I believe at the last hearing, Mr. Visick had also stated he would be filing a proposed parenting plan. So the state had put in proposed orders based on what we knew. But I don't know if that has changed as to what requests will be made today. So it may be best to do the parenting plan piece first, and then we can address child support.
Okay. And I do see that. So Mr. Bissig, you filed a proposed parenting plan recently. Ms. Gibson, have you received that?
I also filed a temporary parenting plan.
That's what I just said. I have I have a temporary parenting plan that you filed. And I'm asking, hold on, I'm asking Ms. Gibson if she's received your proposed parenting plan.
On what date was that filed, Your Honor?
Looks like maybe in our court on September 6th or thereabouts.
I have not received a parenting plan from then on. I received one when he had originally filed for the legal separation.
I
So
have
do you-
proof
but-
of service that day of her being served by Kevin.
So let me back up a little bit. Have the two of you, do the two of you have you exchanged your proposed parenting plans with each other?
Yes, I have, Your Honor.
I have served him with my
Okay,
proposed parenting plan. Yes, Your Honor.
okay. And do we typically, and I'm gonna ask the clerk a question because I saw this on the facilitator worksheet. There's one where they meet with the facilitator even for temporary orders. Or they don't, it's just final. And that, okay. I saw there was that option, so I want to make sure I wasn't missing some step. Okay. Okay. So do the two of you had a chance to talk about your temporary parenting plans and areas that you agree or disagree?
No, Your
No,
Honor.
she don't talk to me or want to communicate with me.
Okay. So it sounds like you are asking me to make the decisions about, well, do I actually,
Your Honor, may I say something?
who is that?
Megan.
Go ahead.
I have tried to contact Mr. Bissig on multiple occasions. He has not answered my phone calls. He has rarely even answered the children's phone calls. So being able to communicate with him about anything has been impossible. I have personally reached out to him multiple times to try to figure this out on our own, but he does not answer me. He will not answer my phone calls whatsoever.
So you guys are very far apart on obviously what you want to see happen here. For instance, Mr. Bissig, you're saying no parent has any evidence of abandonment, neglect, abuse, DV, assault, etc. Ms. Gibson, obviously your allegations are that you're asking the court to restrict visitation because of a lot of, I think you marked every box: neglect, emotional or physical, substance abuse, abusive use of conflict, withholding the child. Sounds like, have you ever had a guardian ad litem in any of your case?
This has been our only case so far, and no, we have not.
Well, that's what I mean. In the entirety, it looks like you filed this case back in July.
Yes,
No,
I
we
did.
have not.
I filed it.
Hold on, petition for legal separation. Have you had a guardian ad litem assigned to your case at all?
No, Your
No,
Honor.
Your Honor.
Okay. What is happening with child visitation right now?
She's withholding the kids from me.
She's what?
She's withholding the kids from me. She won't let me see them. She only lets me talk to them on the phone when she chooses the time.
I have given him multiple opportunities to speak with the children, and he has not taken me up on them. He does not reach out to try to get time with the kids. And when I have offered, he has not taken me up on the offer because it's not what he wants.
Just a second, I'm just going back. Mr. Bissick, if I understand, do you still live with your brother?
Yes, I do. I don't live with my brother. I live with my parents.
I don't, you said yes and no. Do you still live with your brother? Is your brother in the home that you are living in?
Yes.
Okay. And you think that that's a place where you want me to put the kids?
Yes, because he's already taken care of it. He spent his time and the case has already been dismissed. He's not a threat. And Megan multiple times appreciated him and she never cared about it until now.
Okay. What I'm going to do, because I do think there's a safety issue with the children present, I am going to adopt a temporary parenting plan. All that means, though, is that this is what is going to be in effect. While I'm also going to appoint a guardian ad litem to your case. When we go to do final orders, before we get to final orders, I will want lots of input from the guardian ad litem. There's a lot here. So first, let's talk about the guardian ad litem. I think you heard on the prior case, I gave 3 names. The names you have to choose from first are Heather Call, Amy Turnbull, and Ann Height. The parties disagree with any of those names or know any of these individuals and would be uncomfortable with them serving.
No, Your Honor.
I do not disagree.
So I'm going to do Heather Call. You all with some return dates. I'm going to, as a starting point, I'm looking at Ms. Gibson's parenting plan. I am going to reserve. You have, ma'am, you have all the 3A and B disqualifying factors listed. I'm reserving on all of those. I don't have enough information, and so I'm going to white out your X's here. That is something that the guardian ad litem will address with the court. So you'll see on this order, it says reserved. Sir, that means I'm not making any findings that any of those limiting factors apply to you. What's happening currently? Is there any visitation happening with Mr. Biss, supervised or unsupervised?
I've tried doing supervised with me there, but he has only come once. That's when I set it up through his mom so that him and some of his family could come out and see the kids.
Okay. So just for now, for purposes of this temporary order, because it seems like it has been quite some time, and I think the concerns, sir, I have are, I guess the statements. Well, the guardian ad litem is going to look into your household and whether it's a safe place. Right now, I don't think I have enough information to say that it's a safe place for young children, given who resides there. So I am going to require supervised contact with the children only. It can be a professional supervisor or a non-professional supervisor. Who would be the non-professional that you two could agree on?
I agree with my grandma Dodie.
Ma'am, is that an agreeable name for you?
Sorry, I'm thinking. Yeah, I would agree with Grandma Dodie.
Okay, so give me her full name.
Doris Jean Johnson.
And how do you spell the last name?
Johnsson.
Oh, Johnson. I thought you said Jocelyn. Okay. Doris Johnson. And what is the brother's name? I'm putting in a statement that for the temporary order, the children are never to be at Mr. Bissick's home with, and what is his first and last name?
Adam Bissig.
Okay. Okay, I'm gonna reserve on. Let's see. Sir, are you, Mr. Bissick, are you in treatment right now for mental health or substance abuse?
Yes, I've been in there for over 2.5 years.
Okay, so what I'm gonna do is, I'm not gonna require an evaluation because it sounds like you're in treatment. Obviously, this can be revisited based on GL input. You're just to continue with your treatment. Do you do random UAs as a part of that treatment?
Yes, with them and my probation officer.
Okay, so random UAs will need to be clean before any visitation can occur. And if you don't do a UA or one is dirty, then visitation, even supervised, will cease. Right now, I am going to give primary decision making to Ms. Gibson. Dispute resolution, it sounds like we've already talked about mediation and nobody thinks that's likely to be beneficial. So I am going to require that you all come to court. The custodian for now is Megan Gibson. The only visitation schedule right now is the supervised visitation. Let's do, I didn't see in here, did you propose how often supervised visitation was being recommended, Ms. Gibson?
No, I am fine with 1 to 2 times a week. I'm more than happy to discuss with Mr. Bistig if he has a proposed what he would like to see the kids.
Okay, so let's say 1 to 2 times per week up to, what's a workable solution hours wise for you all? Up to, 4 hours a time?
So I do get off work at 2 p.m. and pick them up from daycare by 2:30. That would make it about 7 o'clock. That's reasonable for me from like 3 to 7.
Okay.
He would need to make sure they get fed dinner and everything since we do have a routine as of school with my daughter.
Okay. Summer schedule, same as school. Well, these are the kiddos they're not in school yet.
Zara is in Head Start. She goes Monday through Friday, 8 a.m. to 2 p.m.
Okay. The exchange location for parenting time will be the Kelso Police Department. And then both parents are responsible for raising transportation's median neutral location. But again, if that does occur, if it's professionally supervised, they usually do it at a specific location, or you'd be bringing the kids to that location. If it's grandmother needs to be in the car for the exchange. So what I'm saying is this isn't going to be a situation where Mr. Bissick alone is picking up the kids and then going to grandma's house. Supervised visitation means at all times during the visitation. Okay.
Your Honor, one other
Go ahead.
thing. Would it be possible to have one of those apps for communication so that we can make sure that if he plans on taking them somewhere, I'm aware of where he's taking the children, so that if he's not where he's supposed to be and taking the kids to his parents' house where his brother does live,
Yeah,
That
yeah, so it's called
aware of.
what I can state is parents to communicate regarding locations and timing of supervised visits via our family wizard. And as I understand it, and I've been meaning to log on and check out if this is true. My understanding is it's an app that you use and there is a cost, but when you go to log in or once you log in, you can request a waiver for that cost. It's not much anyway, but there is a small cost, but you can request a waiver for it as I understand it. Okay. So I am going to sign this temporary order and then I'm going to set us some return dates. Any questions or points of clarification that you need from me?
Yeah, I don't really know why you didn't look at any of my evidence or anything.
I'm not sure what you mean by that.
Well, it just seems like you're just going off of her stuff.
I have thoroughly review your evidence, your filing, your case, and I am choosing to adopt her proposal because I believe right now, based on the evidence in front of me, that proposal is in the best interest of the children. It is also what is currently happening, so it causes the least disruption to the children. But sir, I'm not making any final ruling on what your relationship with your children looks like long-term. That's solely within your hands. So what I'm doing is assigning a guardian ad litem, Ms. Call, who is going to meet with both of you, meet with the children, meet with family members, and ultimately make a recommendation to this court about long-term, what is in the best interest of the children. Okay.
Okay.
Okay. Can you give me the ages of the children?
Zara is 4, Aries is 2.
2. Okay. And we'll appoint Heather Paul. Let's get you all some review dates. Okay, let's do a 30, 60, 90. So we'll do a 30 review date, a 60 day, and a 90 day. So if I'm roughly correct on that, we will be back for our first review November 15, 2023 at 9 a.m. Our 60 day will be December 13, 2023 at 9 a.m. And then our 90 is going to be January 17, 2024 at 9 a.m. Okay. And do you need me to repeat any of those dates?
No.
I'm good, Your Honor.
Okay. And then last question, I just want to briefly go over everybody's income to see who is paying or what portion they are paying for GAL. Ms. Gibson, what is your monthly income?
My monthly income is around $2,000 a month.
Okay. How many dependents do you take care of on that?
2.
Okay.
3, including myself.
And do you have anyone else contributing to the household income?
No.
Okay. Mr. Bissick, what's your income?
Roughly around 2,000 a month.
Okay. And how many dependents do you take care of?
Myself and the kids when I have them.
Okay. 2,000 with the 2 dependents plus yourselves. I will find that this will be a county pay case right now, 100% a county pay, but I am going to reserve to a future hearing. We'll take a look again at your finances and see if there's any reimbursement that would be reasonable to be paid to the county. As you heard from the last case, the maximum the county pays is $1,485. And so if we had a hearing on reimbursement, it would be whether I believe the parties can reasonably afford some reimbursement of that amount. Okay, so I think I've got everything I need on guardian ad litem. Are the phone numbers and addresses you all have used to file documents with the court still accurate?
Yes,
Yes,
Your
Your
Honor.
Honor.
Okay. Okay. I think that is it for me. Any other questions?
Yeah, because
No.
I feel like I'm getting misrepresented. I think I'm gonna find a lawyer.
Okay. Yeah, if you, Mr. Bissick, if you hire a lawyer, certainly just have them file their notice of appearance, and then we have specific dockets that we put the attorney represented matters on. So I always encourage people to seek counsel. It will change your hearing dates. That's fine. Okay.
That's okay with me.
Any
And
other,
Your Honor,
any other question? Oh, yes.
yeah, we
Ms.
just
Mooney. Yes.
asked to address child support, Your Honor, before we
Yes.
close.
Let me pull those orders up that I set aside. Okay, go ahead, Ms. Looney.
Thank you, Your Honor. So we did put in a proposed temporary child support order, which had Ms. Gibson as the primary parent, as that was what we knew at the time. And we have taken parents' income from their 2023 employment security data, and we have calculated that at 35 hours per week at their current wages, giving a net monthly income for Mr. Bissick of 2605 and for Ms. Gibson of 2607. So they are at a 50-50 responsibility for the children's care at this time. So the transfer payment that is being requested from Mr. Bissick to Ms. Gibson is $741. That's $370.50 per child. Excuse me.
Okay, and I do see that in front of me. So Mr. Bissick, have you had a chance to review the state's proposed child support order?
Yeah.
Okay, do you have any disagreement with it other than your objection to the underlying custodial parent issue is noted for the record, and it is an issue that you can continue to raise with the court?
Yeah, I feel like the price is a little out there. Like, I don't see how I'm supposed to support myself and do all that and take care of all my bills and still be able to live. So I'd be pretty much working for free at that moment.
Okay. Tell me more. What types of expenses do you have that would render this payment something you would not be able to afford?
I got court fines that I'm paying on, probation fees. I have to pay for treatment myself. And I help my parents out with rent, utilities. I have to buy food, gas to get back and forth to work.
Have you supplied any of that information to the state regarding your, what we would potentially call any extraordinary expenses?
No, they never asked for any of it. They just gave me the temporary one.
Ms. Looney, is it something that you would want to look at and we could revisit this in a week or two, or would the state's position change with that information?
It would not, Your Honor. The items that he's listed would not be reasons to deviate from the standard calculation under the law. So we would not be able to take those into account.
Okay. Are there any other types of expenses, Mr. Bissick, that you have that you want the court to know about?
Yeah, household supplies, cleanliness.
Okay. So much as you've heard Ms. Looney say, the court is going to find that the types of expenditures you're telling me about are not ones that would create any sort of downward deviation of your obligation. I think it's quite fair that essentially the two of you have been deemed essentially 50-50 responsible for the financial costs of the children. The amount being assessed per child, $370.50, is not excessive. I don't find anything in your statements today or the filed documents that would cause me to deviate from that.
Well, I was already paying child support, and I was only paying $450 through the state.
Sorry, say that again. I didn't hear you.
I've already been paying child support through the state, and that's only $450 a month.
For these kids,
Yes.
I'm assuming that's probably because we didn't have a formal parenting plan into place, but maybe I'm wrong. Ms. Looney, what can you tell me about that?
Your Honor, that's an administrative order. The administrative process is different than the court process. So according to the economic table that we have to follow, this is where the child support standard calculation falls.
Okay, I have signed these orders and filed them with the court. Any other questions for me?
No, I'm just gonna get a lawyer.
I completely understand, Mr. Bissick, and I wish you both and your children all the best of luck. Thank you. You're free to log out.
Thank you, Your Honor.
Thank you. Okay, Bissick and Gibson, I think I have them both on here. This is 233-0030-808. Let me just get back into the digital part of that file.
Both parties are,
You're
or
done.
both counties are hopping today, I think.
Yeah,
Everybody's-
right, everyone trying to get things done before the short week next week.
I think it's true.
Okay, so we had a lengthy hearing back on October 18th. We appointed you at that point, so I know it hasn't been a ton of time.
Yeah.
So I think we're just here kind of, my understanding is an initial review, seeing if there's been contact, if paperwork's been filled out.
Yeah, so I have been able to have contact with Ms. Gibson. She completed her intake packet and paperwork, sent it back to me. I have not yet heard from Mr. Bissig. I hope I'm pronouncing that correctly, by the way. Is it Bissig?
Yes.
Yes.
Okay. I texted him. To be fair, I texted him last night, to be fair to Mr. Bissig, but he did receive my packet a little more than 2 weeks ago. Has it been 2 weeks yet? Almost 2 weeks ago. So I haven't had any contact or input from Mr. Bissig yet. I have read through the majority of the case file and kind of seen what's going on. It seems to me, if Your Honor is amenable to this, that a substance abuse evaluation would be appropriate for Mr. Bissig at this time. I would be very curious also about a mental health, but I understand that there's financial restriction. I want to be careful about trying to make too many things happen at once. But a hair follicle test and a substance abuse eval, I think, would be very appropriate for Mr. Bissig going forward. But again, I'm saying this without having read his intake paperwork yet or having had a conversation. So I do want to be aware of that.
Okay. Ms. Gibson, is a hair follicle test and substance abuse evaluation something that you would be requesting of Mr. Bissick?
Yes, as some things have been brought to my attention recently, I would appreciate for a hair follicle test and a new evaluation at a different clinic than he is currently going to for treatment.
What?
So Ms. Gibson, help me understand your request for that if he's already in treatment.
So he's been in treatment for a few years now due to a DUI.
Mhm.
The whole time he's been in treatment that we were together, he never quit drinking like he said he had. The first visitation that he had with the kids, somebody had called me concerned about my children because they were at the same place that he was with the children and said that he seemed very intoxicated.
I don't have that in a sworn declaration or anything, so it's not something I'm going to consider today. Ms. Gibson, if you certainly want to get some sort of statement like that under penalty of perjury, the court could
I will.
consider it. Okay. Mr. Bissick, so I'm going to ask you just a couple questions. First, are you able here pretty quickly to get that packet of info back to the GAL?
Yes, I just haven't checked my email, so I didn't know it was in there until last night when she texted me.
Okay. So we'll give you some additional time to get that done, no problem. And then would you be in agreement to presenting yourself for a hair follicle test? Those results would go to the GAL.
I don't think it's necessary since I'm already in treatment and in mental health, and they already gave me UAs.
I want to be clear to Your Honor, I did not understand that Mr. Bissick was currently in treatment. Like I said, I'm sort of missing some pieces of this puzzle.
Yeah.
So if that's the case and I can contact those folks and receive that information from his current treatment facility, I'm very open to that.
Yeah. So let's do this. Let's do a little bit of a shorter set over. I will take under advisement the hair follicle and sub-eval testing, but I think that does make a lot of sense, Mr. Bissick. If you respond in that packet with the names and contacts for your current mental health and substance abuse treatment, the GAL can review that information and it may negate the need to do anything more. To be fair, sometimes it raises more questions. We just don't know. But I don't think there's enough here for any of us to say for sure that you need to go do these things. So let's have you get that contact information to the GAL and then we can go from there. Okay.
Okay.
Okay. How long do you think you'll need, sir, to fill out that packet and get back in touch?
I can start filling it out today.
Okay. If we did, I know it's going to take I said short set over and then I realized, yes, but we have to request information from treatment providers. So we probably are looking at 30 days, to be honest, at a minimum. So I'm looking at December 13 for a return date. How will that work?
I was under the impression we already had a 60-day review date on December 13th at 9 a.m.
We do actually.
Then that works even better. You all are already available. Thank you for pointing that out, ma'am. So
Your Honor, on that date on the 13th, would you like a written report, an interim written report, or just a verbal review? Would that be
Just
appropriate?
a verbal review would be great.
Okay. Sorry, I lost my train of thought for a second. Go ahead, Your Honor. I apologize.
Well, I was just going to ask if there's anything else that the parties need to talk to the court about today. Otherwise, we'll see you back on the 13th and just encourage Mr. Bissick to get that paperwork back ASAP.
Your Honor, I do have
Yes.
one thing.
Okay.
When we last saw you back in October,
Mhm.
I had requested when we were setting up all the limitations and all that for the visitation that I do receive a itinerary from Mr. Bissick for where he's going to be and what he's going to be doing with the children, so that I do know where the children are going to be at
Mhm.
for their safety. That has been a problem. I had requested and messaged to Zach and Dodie, the supervised visitation, his grandma who does the supervised visitation with him, that I get itinerary a minimum of 12 hours in advance so that I'm aware of where my children are going to be. That hasn't been happening. Communication with him has been very difficult, as when we are doing drop off and pickup, I'm trying to give him necessary information on the children and he just walks away from me. And so I'm just asking for an itinerary in advance, not when we're getting there for drop off.
So help me understand why you're asking for that. I'm looking at the order and it says parents to communicate regarding locations and timing of supervised visits using Our Family Wizard. That's what I wrote into the order.
And
why are you needing itineraries 12 hours ahead of time?
So that I know where my children are going to be, because
how is that any different than getting the itinerary when and within an hour of him picking up the kids or as he's doing it?
I have to ask for it every time
Okay.
when we're doing it. I'm
Okay, I
asking
think-
that he make the communication towards me because he's not making the effort to communicate with me about the children.
Okay, well, I'm denying that request. I think that's an overstep into his parenting time. He does not need to provide an itinerary 12 hours ahead of time to you. This is a situation where everyone is going to have to learn to give a little with regard to your control. I understand that need when it's your kids, but what is in the parenting plan that he does need to comply with is at the time of the visits, he does need to tell you where those visits are taking place. He does. Mr. Bissick, you need to use our family wizard, excuse me, to communicate to Ms. Gibson where your visitation is occurring.
Yes, Your Honor, I can do that, but
Okay.
she don't message me on there. She only asks me when I pick up the kids. So I tell her everything time. My
Perfect.
grandma told her, and she has not contacted my grandma at all.
And that's fine. And I see that Doris Johnson still is the supervisor who must be there at all times. So with that safety guard still in place, I'm not going to require 12-hour notification of where you're going to be. But sir, it is incumbent upon you to use that app and send your itinerary is a strong word. Please let Ms. Gibson know where you are with the children when you are with the children.
I can do that.
Okay.
Your Honor, can I make a
Go ahead.
request regarding our family wizard? I'd like to be able to have access to that communication
Okay.
so that I can monitor if that's helpful.
I think that would be helpful. I call it magic, so I don't know how that actually would happen, but I assume you know how to make that happen.
I do, yes.
Okay.
I just like to sometimes have that included in the minutes so that we can make sure that that's taken care of.
Perfect. I will make that oral ruling that the GAL is to have access to our family wizard communications. Is there any objection, Ms. Gibson or Mr. Bissick, from that?
No, Your
I
Honor.
can agree with that.
Okay. Okay, great. Well, we'll see y'all back on December 13th. Good luck to you all.
Thank you, Your Honor.
All right, thank you. Okay, and then we have Ms. Call here for Bissick and Gibson. Let's go ahead and take that matter. 233-0030808. Do I have Zach Bissig?
Yes, you do.
I have Megan Gibson.
Yes, Your Honor.
Okay, let me just get into your digital file here quickly. 233-0030808. So my docket notes indicate we had originally back in October had a motion hearing on what I believe were going to be temporary orders at that time, if that's correct. We did enter child support orders, but then we set over review hearings on some of the underlying requests, and I think specifically visitation. So maybe first I'll turn it over to our GAL to see where we're at and what we might be anticipating today.
Good morning, Your Honor. Thanks for your patience with me bouncing around a bit today. So at this point in time, I have received intake packets from both parties. However, I didn't receive Mr. Bissig's packet until late last week. I have attempted to set up a home visit and interview with him. I haven't heard back from him on that communication. I have met with Ms. Gibson at this point. I've gone through the case file superficially, and I've read through both of the intake packets. I have let Ms. Gibson know that what I'd be doing today is requesting that the court order both parties to get a hair follicle test. We have pretty serious substance abuse allegations from both parties. I have reasons to believe that Mr. Bissig is still consuming, and I know he's attending. He's he's been upfront about saying he's attending AA, NA, and participating in treatment. I would love to see his attendance sheet that's being signed for him, so I can see who is signing off on his attendance in that program. And I would love to have both parties receive a hair follicle test. That will give me some very much needed information.
So let me turn to petitioner first, Mr. Bissick. I am inclined to grant an order, specifically a hair follicle test for the GAL to be able to move forward with recommendations to the court. Do you have any objection to providing that?
No, but I did send that packet more than a week ago.
You may have, you may have sent it 2 weeks ago. She got it last week.
I sent it by email, so I don't see how that's possible.
Okay. Okay. Well,
I'm
anyway,
happy to pull up the date if we need to, but
No, it's all right. I was just a little confused. That's fine.
Okay.
And I haven't received any word from the GL.
Ms. Gibson, can you hear the court?
Yes, I can, Your Honor.
Okay. Do you have any objection to undergoing a hair follicle test, hopefully before our next review hearing?
No, Your Honor, I have no objections to that. I just need to find a place to do that.
Okay.
And come up with the money, which I was going to ask my parents to help me with.
Okay. It looks like our next review hearing is January 17. I'm not sure what the timeline. I think people can get these done fairly quickly. Do you think there'll be any issue getting that done January 17, Ms. Call? Do you think we need to set that out, or?
In terms of that being the final GAL review, I think it will need to be set out. I don't anticipate that we will have enough information by then to complete a report, especially with the holidays between now and then.
Okay.
There's been quite a delay in trying to get these appointments set up. But I believe if they're both able to get in at Awakenings, I believe they can get that hair follicle test done fairly quickly and get the results back. This time of year, I imagine results are going to take a week or two to get returned. But I mean, I think we're going to have to push the final GAL review, but I think we could get the hair follicle within that time frame.
Okay.
Your Honor.
Yeah, go ahead.
I did call Awakenings, and they do not do 5-panel hair follicle testing, because I did call the same day that I had a meeting with Miss Call.
Okay.
And they do not do those. That's why I'm saying I have to find somewhere to do it. And I'm potentially gonna see, I looked up some places. Quest Diagnostics here in town might potentially do it. So I am going to call there. And if they do, I would be more than happy to message Mr. Bissick and let him know that they do or do not do it, so that he can get his done as well.
Okay. I think that is helpful. Let's, was there anything regarding visitation that the parties needed to re-review today? Otherwise, I think I will set out, I think I'll probably cancel our January 17th hearing and move that into maybe mid to late February.
There was one thing that me and the Guardian Ad Litem had talked about that I would like to bring up. Mr. Bissick does not have the correct car seat for the 2-year-old Aries. He needs to be in a 5-point harness car seat, not a booster seat that is used with the seatbelt.
That's not true, Your Honor. She hasn't seen the inside of my parents' car.
What's not? Well, hold on, you two. No. Address all of your comments to me, not each other. So Mr. Bissick, when you say that is not true, what do you mean?
That she hasn't seen what car seats I put him in.
Okay. Do you have him in a 5-point harness?
I do.
Can you provide a picture of that 5-point harness car seat in your car to the GAL?
Yes, if necessary.
It is necessary. So
Yeah,
I am going to put in an order, and let me just triple check. The youngest child is how old?
He's 2.5.
Yeah, so he does need a 5-point harness. So I am going to put in the bench order that since you say you already have it, I'm going to say within 24 hours, I want you to send a picture of a 5-point harness car seat in your car
So the picture needs to show that it is your vehicle or whatever vehicle, if it's your parents' vehicle, fine. It just needs to show that it is the vehicle that you pick up or drive the child in with a 5-point harness car seat. And until the GAL has that, I do think it is inappropriate for you to be driving the child around because a booster seat is not appropriate for a 2.5-year-old. It is not safe.
Well, the person who is watching and supervising me is here, and she can verify that's not true.
I don't need to take anyone's word for it. I'm just asking you to send a picture of it in the vehicle to the GAL.
Okay.
Are you not able to do that?
No, I said that's fine.
Okay.
I did.
Go
Sorry.
ahead. Go ahead.
I
Ms.
did have
Bishop.
two more things I wanted to discuss. One was I wanted to speak with you about potentially extending a visitation time, extending the amount of time for visitation on the 23rd so that Mr. Bissett could get more time with them on the 23rd to do Christmas with them, potentially going to 6 hours that day instead of the 4.
And since that is more visitation and not less, if the two of you agree on that, I am fine with it. I don't need to put that in an order. If it's a holiday thing and you're not asking me to restrict visitation, you just want to give them a little more time. Mr. Bissett, I assume you're in agreement with that?
Yeah, that'd be nice.
Perfect. There we go. I think that's all that needs to happen
perfect
on that issue. Yeah.
I wasn't sure. I wanted to just double check. And then the last thing was, I had messaged Mr. Bissett on November 30th to give him 15 days notice of a trip that me and the kids will be taking to visit my mom and my stepdad for their Christmas with their grandparents. I let him know that because we have been doing Saturdays, we will need to work something else out. It is now the 13th. We leave on Friday, which is the 15th. We will not be returning till the 17th.
Okay.
There's been no communication. I verbally reminded him last Saturday. He has not communicated with me about what he wants to do for visitation. So I'm not sure what I should be doing because I don't want to get in trouble for not having visitation, but I have given him ample time to communicate with me and to work something out with me for visitation this week.
Understood. So what day? So while you're gone, will he just be missing one visitation day?
Yeah, so we've only been doing it once a week, Saturdays from 3 p.m. to 7 p.m. because there's no set day that we have to do it.
Right.
That's just what has been working for both of us. But seeing as we will be gone this Saturday, I wanted to give him ample time to work out something else with me.
Is there a makeup day, Mr. Bissett, that will work for you because they will be gone this upcoming Saturday?
Well, it's supposed to be 1 to 2 days a week, and she's only given me one.
Yeah, it does say 1 to 2 times per week, but that's not my question. My question is, since they will be gone this Saturday, and I'm not going to preclude her from being gone over a Saturday for a holiday trip. My question is there a makeup day this week or next week that would take the place of this Saturday for you that works for you and the supervisor?
I'm pretty sure we can figure something out.
Well, why don't we do it here? Because it sounds like I feel like this is going to be a little bit stressful for her, and you seem a little ambivalent about whether you're going to work with her on this. So I would like to set that date here. You said you have the supervisor with you. What will work? What will work for the two of you?
How about Friday before they leave?
Well, I think they're leaving.
So Friday would work if it was the 3 to 7 like we originally planned. We have to be at the train station by 7:30 on Friday. So that would work for me.
This Friday, meaning in 2 days?
Yes, if the 3 to 7 would work, or any time from after 3 to 7 o'clock, that would work for me.
Mr. Bissett, does that work for you? I feel like that's cutting it a little close for getting your train, but if you think it'll work, I'm happy.
It's right there by the police station.
Yeah, the police station and the train station are right next to each other, so that works.
Oh, that's true. That is right up here. Okay. Well, Mr. Bissick and Ms. Gibson, if that works for you, I think that's great. Gives me a little travel stress, but if it works for the two of you, I'm all in favor of it.
That works for me if that works for him.
Okay. I know I'm one of those people that shows up like 4 hours early for my flight. So
Oh, our train
but-
doesn't leave till 8. That's why I'm saying we have to be there at 7:30.
Oh, okay. I thought it was leaving at 7:30.
No, 8 o'clock.
Okay. Okay. So let's go ahead and then also, I'm not, again, since it's just a one-off, I'm not going to put that in a specific order, but it will be in the clerk's minutes if an issue comes up that we need to address. But what I am going to say this week, instead of Saturday, Mr. Bissick, go ahead and plan on Friday from 3 to 7. Okay.
It's not like I have a choice in the matter.
Well, you do. I asked you what worked for you. So, and the choices, what I'm telling you is I'm not going to preclude a travel trip over the holidays. So we're trying to find a date that works for you. That's kind of part of parenting through a separation is it's maybe not always going to be either party's first choice, but I'm asking what is workable. So if Friday doesn't work,
what's workable is I should be able to get my 2 days a week.
All right, sir, I'm not going to get in an argument with you. What I'm asking is Friday a sufficient day for you? Does it work for you? Or do you want to look at a different day, perhaps next week?
That works.
Okay. Okay, anything else we need to do before I look at new dates for our case?
That's all I had, Your Honor.
Okay, so in the bench order today, I'm going to be requiring hair follicle testing by both parties. Let's say, try to get those done. I'll say 3 weeks just because I know holidays are coming up and I know that you might need to save a little money for it. But unless Ms. Call, you want that to be a tighter turnaround.
No, I think that's fair. I think both of these parties are going to need a minute to put that in order. And I offer my apologies to Ms. Gibson. I thought Awakenings would be able to do that for her. I must have had some wires crossed there on location.
Okay.
That's okay.
And then I will require in the next 24 hours that Mr. Bissick send confirmation of the 5-point harness in the car that the minor child will be in, the youngest child. So let's cancel January 17th. And certainly this doesn't preclude any party from noting an issue on to our Wednesday docket if something comes up. But instead of doing the formal review date on January 17th, let's go out to, let's try for February, well, how about February 21, Wednesday at 9 a.m.?
That works for me, Your Honor.
That works for me.
And Mr. Bissick, does Wednesday, February 21 work for you?
Perfect.
Okay. All right, we've got you on there. And I will get that bench order written. Anything else either you need from me today?
Nope.
No, Your Honor, I'm got everything I needed today. Thank you.
Okay, thank you. Ms. Call, anything from you?
That's all I needed. Thank you, Your Honor.
Okay, thank you.
Zach Bissig and Megan Gibson, cause number 23-30808. Zach Bissig, are you on the line today?
Yes, I am, Your Honor.
Welcome, sir. Megan Gibson, are you on the line today?
Yes, Your Honor.
Welcome to you. And I see Ms. Kell is on the line.
Good morning, Your Honor.
Morning. I see that this is a motion brought by Ms. Kell related to moving the date of the report out to March 19th based on inpatient status of Mr. Bissick, or was an inpatient, and looking to move it to that date. Anything further, Ms. Kell?
Not at this time. I understand Mr. Bissig came out of inpatient treatment just a couple of days ago, so I'd like to offer congratulations to him on that.
Great, thanks. Okay, and Mr. Bissick, any concerns related to the GAL's motion to extend the date to file a report?
No, I totally agree with her.
Okay, Ms. Gibson, do you have any concerns?
Yes, Your Honor, I have a couple of concerns which I have voiced with Mrs. Kale um, through our communication. I have no problems giving Zach a chance to prove that he can be the parent that I know that he can be for our children. My only concerns is I understand that this process is a very long process, but we've been going through this with this parenting plan for 4 months now. Mr. Bissick has not been complying to everything like he's supposed to be, i.e. the uh, guardian ad litem investigation, the hair follicle test. Um, he didn't send the car seat picture like he was supposed to until weeks later, staying sober. Like, I've done everything asked of me. He has not been doing what has been asked of him these last 4 months. The only reason he went to treatment is because he got in trouble again and was court ordered because of his DUI to go. I would have no hesitations with this if it was him choosing to go on his own to better himself, not only for himself, but for our children. But that wasn't the case.
So thank you, Ms. Gibson. So there's a motion brought by Ms. Kell to move the due date to March 19th. You've specified some concerns related to noncompliance. If you have concerns related to noncompliance, any party, for that matter, if they have concerns regarding compliance of a court order, one of the remedies that a party can pursue is a motion for contempt for failure to follow a court order. So that's an option if you have concerns related to any court order. As far as your the motion to move it to March 19th, it sounds like you are concerned that it may be taking too long and the like. Other than that, do you have any additional concerns about setting the hearing to March 19th?
I'm having to take time off of work to be here every time we have court, and I'm the only one supporting our children currently. So I'm just saying that, like, I have no problems moving it. I just feel that it's very unfair to me and my children who, like, I've been doing everything asked of me. I'm the one that sits here with my kids when they're crying because they want their dad, but he's not making the appropriate choices. But yet we're giving him yet another chance after he has repeatedly not done what he's supposed to be doing.
I'll grant the motion. We'll set the matter to March 19th at 9 o'clock in the morning. Each party will have an opportunity to review that, and we'll review it on that date. And if there's pressing concerns, we can make some adjustments. Any questions?
Yeah, I just want to state the fact that I was not court ordered to go to inpatient. I did not get in trouble. I put myself there.
Particular points. Both of you, those are important things that you're sharing. They are important for today's purposes. There was a motion before the court related to a hearing date. I've made that decision, so we can address those issues when we come back on March 19th. Thank you.
Thank you. I appreciate you.
They did not appear on the March 18th docket, and we don't see them again for 7 months. I'm not sure why.
The other matter that's slated today, which I wasn't made aware of until earlier or in the middle of the docket, was the Bissick and Gibson matter. So I don't know if the Bissick and Gibson parties are present.
I am, Your Honor. My name is Megan Gibson.
Okay. So my apologies. So normally what happens is that the docket is loaded up. I review it. Apparently there was a miscue and it didn't get loaded up. So I didn't know it was on the docket. And then midway through the docket, I found out it was on my docket. I haven't read anything. I don't know anything about the case, unfortunately, and we're out of time today. So my apologies for 4 hours of your time this morning. It's significant. What I would ask if both parties, Ms. Gibson, Mr. Bissick, if you're available next week.
I was going to ask, Your Honor, if we could potentially postpone it for 2 weeks. I am taking my children on a camping trip for a week coming up this week, and I won't have service.
Okay, Mr. Bissick.
He's not present, it doesn't look like, Your Honor.
He is, and I'll ask him to come forward and just maybe get to the microphone so everybody can hear his voice. Because I can see him, I can hear him, but the rest of you on Zoom probably can't. I apologize. So you're Mr. Bissick, correct?
Yeah, I'm here.
Okay. So there's a request to continue the matter by myself, and then I suggested the 14th. Ms. Gibson suggested the 21st. Do you have a preference?
No, it's fine.
Okay, well, let's set it over to the 21st, August 21st. That's a Wednesday at 9 o'clock in the morning. We'll set it to that date and time. And let me just double check to make sure because I haven't looked at the case at all. It looks like there was proper service. And then have you filed anything in response, Mr. Bissig?
No, I didn't know I needed to.
Okay.
But it's gonna give me time to.
Yeah, if you want to, you can certainly file that with the court and send a copy over to Ms. Gibson, so she has awareness of what you're saying. So we'll reconvene on the 21st. Ms. Kell, does that work for you, the 21st?
It does. I'm a little packed in on other matters as well, so it'll be a similar situation where I'm bouncing around, but I'll be here the best of my ability.
That's kind of you. I appreciate that. Thanks.
All right.
All right.
Thank you.
Thank you, Your Honor.
Apologies again, and we'll see everybody on the 21st. Next matter is Zach Bizik and Megan Gibson, 23-300-308-08. Zach Bizik, are you on the line? You're here. You're in person. Come on up and take a seat, Mr. Bizik. All right, and then Megan Gibson, are you on the line?
I am, Your Honor.
Okay, welcome to you. And then Miss Call, you're here?
Yes, good afternoon, Your Honor.
Good afternoon. Let me just check one item here. All right, we're here on Ms. Gibson's motion for contempt related to parenting plan and missed visits. And we were here previously on the 7th of August, it looks like. And at that time, we set it over to today. And let me just ask Mr. Bizik if you filed a response to this, because the court file doesn't show that a response has been filed.
Yeah, I was able to do it yesterday, and I was able to give Megan a copy of it when she was served. But I got it all scheduled and filed yesterday.
Yesterday, okay.
So if you want to just continue it out and give it some time to go through the system, and I'm okay with that.
Okay. All right, and so it's okay. So you got it to the clerk's office yesterday. Ms. Gibson got a copy of it. Ms. Gibson, did you get a copy of his reply?
Yes, I got it yesterday afternoon.
Okay. Ms. Call, I see that you're on the line, and I was just double checking on sometimes on my Odyssey edition, sometimes it'll be clear the guardian ad litem has been appointed and I'll show up. Other times it's not. You've been appointed in this case.
I have, and actually, Your Honor, I wanted to point out that there has been a guardian ad litem report filed that has yet to be reviewed. And I think that some of these concerns that Ms. Gibson has may be addressed within that report.
And that's your report that was filed back in March.
Correct, yes.
Okay. That's something that we should probably review. Mr. Bizik, did you get a copy of that? Do you have a copy of that?
Yes.
Okay. Ms. Gibson, do you have a copy of that?
Yes, I do, Your Honor.
Okay. So with the filing of the Mr. Bizik's reply, I haven't read it. Ms. Call, would you, Mr. Bizik, would you mind getting a copy to Ms. Call so she has a copy of your reply to the motion?
Yes.
Okay, that'd be great. So
I have not received copies of anything from either party. I can retrieve those things on Odyssey. I just was made aware that this issue had come up. I've been encouraging Ms. Gibson to file a motion to get the report reviewed. I know Mr. Bissick spent some time in jail recently, so this has gotten more complicated since the filing of the report. But I think that review will be helpful in some of these issues.
Okay. So let me touch base with the party. So the motion for contempt, I think, Ms. Gibson, do you have any strong objection if we were to set that matter over so I can read Mr. Bissick's reply to your motion?
No, I don't have any objections.
Okay. So let's take a look. What I'd like to do is set it over 2 weeks so we can address the motion for contempt. I'm looking at a September 4 date at 9 o'clock in the morning or 12:30 in the afternoon, depending on when we get to it. And on that date also, we would review the guardian ad litem report that was filed on March 14th. So that means if you read over Ms. Call's report and either you agree with it or you disagree with it, I want something in writing from each of you, so I know what your respective positions are, if that's what she's recommending, if you think that's a good idea or if that's a bad idea. So I want you to, so you'd submit something to the court, give it a copy to the other party and send a copy to Ms. Call so she knows, she's aware also, so everybody's just in the know. And that would need to happen sooner rather than later. So I would encourage you to have that submitted by next Wednesday. So it can get into the court file and be uploaded, and so I can read it and be aware of what your positions are. Are you comfortable doing that, Ms. Gibson?
Yes, I do have two questions for you, Your Honor.
Okay.
So one, our statements on her proposed plan, do we need to submit that or have that served to the other party as well as Miss Call, or just to Miss Call into the court?
Everybody needs to know. So you'd give a copy to Mr. Bissick and Ms. Call and to the court. Yeah.
And then my second question had to do with pushing the date out. My only concern with Wednesday the 4th is I do help take care of my little sister. I get paid to do so from my parents. Both my little sister and mine and Mr. Bissick's daughter are going to be starting kindergarten on the 3rd. And we aren't sure yet on if they're going to be it's going to be half days. I'm not sure on whether or not the girls are going to be in the mornings or the afternoons. And so pick up and drop off is going to be a little hectic for this first week of school happening starting the 3rd. I'm not 100% sure on what our schedule quite is.
Would you be comfortable if we came back on the 11th of September, Mr. Bissick?
That's fine.
Ms. Gibson, September 11th?
That works for me, yes.
Ms. Call?
That's much better for me than the 4th. Yes, Your Honor.
Good. All right, so we'll come back on September 11th at 9 o'clock in the morning. We're going to address the contempt motion, and we'll have read what you've submitted. And then both parties are going to submit information, your response to the guardian ad litem's March 14th report. If you need to get a copy of that, check with the clerk's office. But you'll both write your response, submit it to the court, give a copy to Ms. Call, give a copy to the court. And then we'll go from there on the 11th and make some decisions. Any questions?
None at all.
Ms. Gibson, any questions?
Nope, that was it. Thank you.
Paul?
I'm good. Thank you, Your Honor.
Thanks everybody for your patience. We'll see if we can get to you much earlier in the docket next time.
All right. Thank you.
Thank you.
Thanks. Next I have Zach Bissick and Megan Gibson, 23-3-30808. As I see Ms. Call is on the line, and then we've got Zach Bissick present in the courtroom.
Yes.
And then is Megan Gibson online?
I am, Your Honor.
Okay, very good. So as you heard me describe just earlier with the other group, we're at a point where I think we need to continue the matter, and I apologize for the wasting of your time. That certainly is not my intent, nor do I like to do that. This is on a motion brought by Ms. Gibson regarding contempt, and also just a quick review from the guardian ad litem, which has implications related to parenting plan. So my request is from the parties to set this over 1 week and hopefully address it earlier in the docket rather than later. And I just want to know, does that impose any undue burden on either party? Mr. Bissick, start with you.
That sounds good to me.
Okay. All right, Ms. Gibson.
I have no objections to that, Your Honor. I'm just curious on if you can ask Mr. Bissick if email service would be okay for the documents that I've been trying to get him served for.
Okay, Mr. Bissick, do you have a position related to electronic service of documents?
No, I'm okay with that. I can do the same.
I'm fine with that.
Okay, do you both have each other's email addresses?
Yeah.
Yes.
Okay. Yeah, I'm fine with that if you want to do that. And then Ms. Gale, how about your schedule?
I'm a little jammed up next week, but I will be here.
Okay. I appreciate everybody's patience and flexibility. And again, my apologies. We weren't able to address the case today. So we'll set over 1 week, September 18th, 9 o'clock, and I'll make sure that we hear it earlier in the docket rather than later, so this does not happen again.
All right.
Okay.
Thank you, Your Honor.
Thank you.
And then I've got Zach Lee Bissig and Megan Gibson. And I think we have Heather
Here, Your Honor.
Paul. Good
Good
morning.
morning, Your Honor.
Thought I saw your name on Zoom, and I did.
Just to let Your Honor know, I'm also being pulled over to Clark at the moment. But I've just informed them I'm here on this. So if I have to hop
Okay.
out.
I just, this one is a little, I looked at the contempt motion, which was And is Megan here?
I'm
I
here,
see
Your
someone.
Honor.
There we go. Okay. I thought I had seen your name, so give me just a minute here. So there was a motion for contempt. This was filed July 9th. That's the one we're working on. Is that right?
Yeah, we were also supposed to be discussing the order, the recommended order placed by the GAL that we both did declarations for.
Yeah, we haven't had a review of my report yet, Your Honor.
Okay, I assume that was just to see if it had been filed. That was the one you filed March?
Correct. Yeah. We had Mr. Bissick spent some time in jail, so we had kind of an interruption in the case. And I know that Ms. Gibson had a filing of contempt. And so we have yet to get to the parenting plan issue.
Okay, so I guess I misunderstood. I thought this was just on to review, and I guess I didn't see the one way back in March, as to whether it had been filed or not. I did see the declarations about disagreement with the report. Okay, I really, based on the notes that I have, it's not clear what Judge Evans was wanting today. It just says he was filing. So what was heard on August 21st?
Well, this is the tough part of the case, Your Honor, is Judge Evans, the last two times we've come before him, we were the last case called and he had run out of time on the docket because he'd gone overtime. So we've just been pushed and pushed. This is our third attempt to get the case heard.
Okay.
I told Ms. Gibson this case has had bad luck.
Right. My question, and I apologize for the scheduling today. I'm not sure how that happened, but I have a contempt motion that was filed back in July, or a contempt order, and that was related specifically to not showing up for visits. I believe is the total of that. Is that accurate?
Yes, Your Honor. Mr. Bissick had missed multiple visits within a 2-month period without letting me know that he wasn't going to be present for those visits. There was no communication whatsoever. And this is something that he was fighting and fighting and fighting for, to see the children, but then just failed to show up and decided to do other things instead of coming to see his kids for the scheduled time that we had set.
So we've got 3 visits that were missed without notice.
Without notice, yes.
Okay.
There was more visits missed. I think there was 4 in total, but he did let me know of one that was going to be missed. He did message me on the Our Family Wizard app and let me know that he would not be present for that visit. But the other 3, there was no communication at all.
Okay. And did you have a response to that specifically, sir?
Yeah, the allegations towards it all is just not accurate. So,
Well, did you miss, there were 3 visits that she listed pretty specifically. Did you miss those or not?
no, there is no evidence to support that claim.
But there's evidence is that she said you didn't miss them. Do you have some evidence that you didn't miss them?
No, I don't know how to prove that.
So are you saying you did visit on March 8th, March 16th, April 20th, and May 11th?
Yeah, I've had my kids on those days.
Okay, so you, what's your,
Get them 4 hours, so there's no timestamp on either of us showing.
Your Honor, these two parties have been communicating and calendaring through Our Family Wizard. I'm wondering if there's some ability to pull that information.
I don't have any way to pull that. I don't.
Right, yeah. But I wondered if Ms. Gibson might have access to that.
I am checking, and I know that I am trying to figure out why some of my messages are missing on here. Because there were messages. Oh, there we go. Now I can see them. Sorry. I have a message from the 11th of me telling him that at 3:14 p.m., which is one of the days that he missed, that if I said, hello, if you're not going to show up, can you please at least message me so that one, I don't get the kids' hopes up, and two, I don't waste my gas. Thanks. What were the other dates? I'm sorry.
Let me see here just a second. It looks like it is the March 16th, April 20th, and May 11th.
All right, March 16th. Inbox. The March 16th one, he went to the beach with his family, and I have picture proof of that. He wanted to take the kids with them. I spoke with Heather about this instance of he was wanting to take the kids to Long Beach with his family, but I knew his brother was going to be present, and for our temporary parenting plan, the kids are not supposed to be around their brother. He said that he was going to come back into town and never did. Because he had asked if I was going to let him have them. I asked if him and his grandma were going to be in the Longview Kelso area. He said yes. He asked if I was going to give them to him, and I said yes. And then he never showed up. And then
Okay, so I guess I'm confused there. You said he asked to go on a family trip. You said no, but you said he could visit otherwise?
he could be visiting in they went to Long Beach, Washington for the weekend. He wanted to take them for the weekend to Long Beach.
Okay.
And I told him no, because I knew his brother was going to be present. And as for pictures that have surfaced from that trip, it was true that his brother was present. I also spoke with the GAL about it. And so I told him no to taking them out of town for the visitation for a full weekend or anything like that. Told him that he could visit them here in town in the Longview Kelso area where we both live for the scheduled visitation.
Your Honor, the issue with Mr. Bissig's brother is that he's a registered sex offender and has been convicted.
That is a lie, sir. He's not registered, and I put that in evidence.
I saw he's not required to do that anymore is what
Yeah, that was,
my understanding of that, but
That's clear, yes.
that still looks like that's what's in your temporary plan, though, that until that's changed, that's a restriction.
yes, and I've
Okay.
been following that restriction.
Okay, so and I'm just looking at the contempt issue right now.
Well, and that's another one of my issues on the contempt. I put it in there that, and Miss Kale has spoken to my daughter a one-on-one about what has been happening and what my daughter has been saying. But my daughter has been saying when they were doing visitation with their dad that Adam was present. And my daughter's 5. She has no reason to lie to me. And when she does lie to me, I know when she's lying. I trust my 5-year-old that.
Okay. All right. Well, let's talk about these other visits we're talking about. One was April 20th.
Yes. I had I don't have like proof that he didn't show up that day, but I have messages that I asked to switch visitation to Sunday instead, and he could have a couple extra hours with them, which we've done in the past. And when he replied, he said, we can just stick to the regular schedule because I have it set up for Saturday, but then he just didn't show up.
That was April 20th.
Yes. Well, April 18th that those messages were exchanged, but he didn't show up on the 20th after saying that we were going to keep it on that day.
Okay.
And then I showed up on Sunday as well, just in case he changed his mind and didn't say anything to me. And he didn't show up on Sunday either.
Okay. And then May 11th.
Yes, May 11th, I had sent him the message asking that if he wasn't going to show up, to please let me know, because every time I show up there and he doesn't show up, I deal with hours and hours of crying and torn up children because their dad didn't show up. And so I'd asked him to let me know if he wasn't going to show up. And I have the message on my phone that he has still yet to open and look at from that day.
Okay. So and you're saying you did those visits, sir?
Yeah, I don't recall that. Never getting a text like that or nothing on the Family Wizard. It has been glitching on me a lot, so.
Okay.
I do recall one of those days I was sick and I didn't show up, but the other two I did too.
Okay. The problem that I'm faced with here is I've got a parenting plan that has no specificity other than 1 to 2 times per week up to 4 hours. It doesn't have a specific, it doesn't.
There's no specific dates. Yes, I'm aware.
Yeah. So I don't know how I would be able to make a contempt finding based on that. The contempt has to be something that's specified in the order.
Okay. Well,
So
I mean,
I don't know that I can.
Okay, those weeks there just was no visitation. He didn't show up because we have had a set schedule between us for what days to do visitation and everything, and communication between me and him, but he just hasn't shown up those weeks.
Okay. So Miss Call, you had filed your report on this case, looks like back in March.
Yes, Your Honor.
And get back to that here. Because obviously the parties have some disagreement with your recommendation.
Yep. I will say, Your Honor, if it's of any help or use to you, Ms. Gibson has been in contact with me since I filed the report on a fairly regular basis and has reached out to me with questions and has reached out to say when Mr. Bissick doesn't show up. And, you know, this thing about his brother being present, even when I went to the home to do a home visit to observe him with his children, his brother was there in the house. And I was really confused by that because we had just had this whole conversation around it. Mr. Bissick claimed that he believed that that was not going to be a problem. I'm not sure why he thought that. But I'm having, to be totally honest, I'm having a hard time believing Mr. Bissick right now. Just because we've had so much communication.
Sir, I'll listen to you. I'm listening to Ms. Call right now. Go ahead.
Only because I've had so much communication with Ms. Gibson. And in the beginning of this case, I was really working hard with Mr. Bissick to help him get to a place where he could have a more steady and consistent relationship with his children. I know how much he desires that. We have a pretty serious substance abuse issue at play, and then some jail time over a warrant. And I think Ms. Gibson's complaints are valid. And I think that she's correct to say there's some issues here that need to get fixed before the children before Mr. Bissick has free access to the children without some standards in place.
So I guess at this point, and again, I'm a little confused on what we're doing today. There was a contempt motion, which I don't know that I can find based on the existing plan and the evidence that I've heard, and what's listed in that document. And I don't know if it was Judge Evans is planning on doing something different with a parenting plan based on this.
I think the hiccup has always been that we haven't had a review of the report. So there are no adoptions in place of recommendations or an updated parenting plan to this point. And so I think that that's caused, and my understanding today was that that's what Judge Evans was going to do, was to go through the report. But I fully understand that there may not be notes to that effect.
Well, and normally that would require a motion anyway to do something which I don't have.
Correct, yeah.
The only motion I had really was the contempt motion that was on for review. And you folks, you filed some responses to that. And so really, I guess at this juncture, what I'm going to suggest we do on this, if either of you are asking for the court to adopt the recommended plan from Ms. Call or something different, is that you file a specific motion that is asking for that to happen. The fact that there's been a recommendation made, that tells me what the recommendation is. There's a lot in there, and there's a number of concerns that have been raised. And this likely will be a case that goes to trial unless the two of you come to some agreements. But that's not the issue today. The issue today is what do we do on a temporary basis, if anything. And so I guess what I'd want to have from each of you, or one of you at least, with the other could respond to it, is what you would like to see the court do at this point moving forward. Your current plan has some real unstructured visits that it sounds like there have been some challenges with. And I guess what I would probably good would be some sort of a proposal for some sort of a specific schedule, subject, of course, to whatever the limitations that are determined to be appropriate based on the recommendation.
Okay, I have a question, Your Honor. Now, when you say the file something, does that do you mean like another proposed parenting plan? And
that would be a good place to start, right? A motion to adopt what you would like to see happen based upon the parenting plan recommendation. Okay. And you could do the same, sir.
Yeah, I'd rather work as a team and make a reasonable, agreeable parenting plan that works for both of us.
The two of you can come up with agreements, but that is subject to approval by the court based on, to a large degree on what's been recommended as well. But so at this point, I'm going to deny the contempt motion. And then I'd like to see what each of you would like to see the court do moving forward. And I've seen your declaration, so we don't need another declaration. Really just a motion as to specifically what you'd like to see in a parenting plan. Okay. And then we can make a determination on a temporary basis what should happen. And if that is or if you both agree to something, that very well may be a final one. But this is a legal separation case, it looks like. So there are some additional paperwork that would need to be filed before it was completed.
And Your Honor, do you know which one, what the form is that you're asking for?
It would just be a general motion at this time and then a proposed parenting plan.
So the general motion and the FL All Family 140? That's
probably fine.
Okay.
Yeah. And then a new parenting plan with your proposal based on what you've seen in the recommendation. Okay. And Ms. Call, I know you're moving on to other pastures shortly. You may end up getting requested to come back for a trial if that's the case, but we do have your report obviously in the file. It's pretty self-explanatory. And based on that, if you want to forward me or forward to just the court generally, I won't be here for a couple of weeks. Request for any additional fees you've got on this case, and then a relief, whatever we're doing for discharging you.
Yes, thank you, Your Honor. I have permission to keep myself available for trials and such going forward, so I will be available for that. And thank you for your support.
Okay, very good. All right, so that's what we'll do today, and then we'll await a further motion. I won't set another hearing today, so you'll need to set it. You will need a notice of hearing that he would need to be served if you're going to file that, and if you want to file it, you'd have to serve her those papers as well. And again, if the two of you come to some agreements, you may want to come back before the court and see if Judge Evans or myself are comfortable with what that agreement is.
Appreciate that.
Okay,
Question, Your Honor. Seeing as service has been very difficult on both ends, can we continue with the email service?
you have any objection to that, sir?
Oh, no, that'll be fine.
That'll be fine.
All right, thank you.
So email service, either direction would be fine. Ms. Call does not need to be served, so you don't need to fill her email box up because we're relieving her at this point unless we drag her back for trial.
Okay, thank you.
Okay. You're welcome.
Thank you, Your Honor.
You're welcome.